All right, the next case to come before the court is Brian, is it Heaney or Heaney? Heaney, thank you. Brian Heaney et al. Versus Crystal Clinic Orthopaedic Center. Both sides will have 15 minutes to present their argument. Mr. Mendenhall, you can reserve up to 5 minutes for rebuttal. Just let me know before you get started. I don't have to talk to you about victims or children in this case, so we won't go there. We have read your briefs and we are ready to begin when you are.
Thank you very much. May it please the court, my name is Warner Mendenhall. I represent the parties in this matter. And I would like to reserve 5 minutes for rebuttal. This case involves construction of a 49-foot tall orthopedic hospital on property that's adjacent to the plaintiff's property. We went through the trial court, tried to get a TRO, tried to get a preliminary injunction, and failed at that. Then the judge in that case ruled and dismissed the setback deed restriction, dismissed the height restriction part of the complaint, and dismissed the complaint as being moot. So this appeal has 3 issues. One was who should be parties in this case, and whether appellants should name all the property owners subject to the setback deed restriction as necessary parties. Secondly, whether we pled sufficient facts to prove that the height restriction in the deed was for my client's benefits. And third, whether the enforcement of the setback and the height restrictions was moot. So I'd like to deal with the first issue of necessary parties. The stormwater installation that is involved with the 70-foot setback was built within a buffer zone that was clearly established in the original documents in this case. The court below found that adjacent neighbors were not included in the complaint and that they were necessary parties, and they dismissed our case for failing to name them. But I think the case law is clear, and we lay that out very much in the brief. Whether a party is a necessary party depends on whether they have a legally protectable interest in the rights that are subject matter to the action. Just because a person has a legal interest doesn't mean that they have to be included, though. In this case, what my client was doing was protecting the legal interest. It wasn't changing a legal interest or adding an obligation based on some kind of agreement. It was just merely protecting what legal rights were there already in place. It wasn't trying to add new membership fees like the Bretton Ridge case. It wasn't trying to change the legal rights of the neighbors. So when the trial court found in their favor, saying that these were indispensable parties, that's just not true. The only other party that was an indispensable party was the Crystal Clinic, whose rights certainly would have been affected by the setback restrictions and by the height requirements. The second issue is the height restriction and who that was to benefit. And there's a long history going way back to 1987 in terms of the deeds and the documents that apply to this property. The height limitation that ultimately was agreed to by Delegnese was a 36-foot height restriction. And then he reserved to himself an arbitrary power to change the deed restrictions. But we don't believe that he properly consulted with the neighbors to do that. He didn't have the right sign-offs to do that, and arbitrarily increased the height to 50 feet. The declarations do not, in the deeds, do not explicitly state plaintiffs were the intended beneficiaries, but the surrounding circumstances of their creation show that they were intended to be the beneficiaries. The Berger versus Swearigan case, if land is developed to a uniform general plan and the intent is to develop the land, it is shown, reasonable restrictive covenants may be enforced. The intention of the parties to this question is gained from the language of the instrument and the surrounding circumstances. So whose benefit was it? Originally, the plaintiff's property and Crystal Clinic property were jointly owned by the Delagnese Company and the Crystal Lake Associates, and they were to be residentially developed. Then Delagnese split off from Crystal Lake Associates and decided to make what now is the Crystal Clinic property be developed commercially. In that process, he tried to get zoning change through Bath Township over the Crystal Shores and Sanctuary residents' opposition. And then, because he couldn't get Bath Township to go along, he had the property next to Fairlawn. In the Fairlawn annexation process, he agreed in that process to the 36-foot height restriction to protect exactly that, the neighbors. And then he codified that as a deed restriction, the height in the deed restriction. So these factual allegations set up circumstances that show that the 36-foot height restriction was to benefit the neighbors. Who else would that be for? It's not, it's not for Delagnese, that's a limitation on himself.
Was there any Fairlawn zoning rules that required nothing to be over 36 feet?
This case is not about zoning, and I think that's an important point because a lot of the cases that are cited on the other side have to do with zoning regulations. This is not zoning. This is merely the ability to enforce deed restrictions. It's limited to that. Fairlawn zoning regulations are not actually relevant to either the setback issue or to the height restriction issue. So under the pleading standards and the way this case was handled under a motion to dismiss, the trial court should have assumed this factual question was in our favor, and it did not, and we believe that's reversible error. The final issue here is, of course, mootness. The first finding by the trial court is that because construction has commenced, and I looked up today the final affidavit, I think the 5th affidavit of construction, that this was moot because it had commenced. A couple of things about that. First of all, the building is not yet built to either the 36-foot or 50-foot height restriction. So yes, it would require a redesign of the building, but it wouldn't. We're not here asking that the building be stopped in its construction. The foundation's in, some preliminary walls are in. We're not asking for that to stop. So yes, the land has been permanently altered, but the height has not been set. And the violation has not yet occurred of the 36-foot height restriction, so the case is not moot. And that was, the case that was cited by the court was Neighbors for Responsible Land Use, which actually I was a part of, and that issue was a zoning case, and specifically a conditional use zoning case, and this is a deed restriction case. So we're not asking to stop the construction entirely, but just that aspect. The other mootness issue is the setback restriction. As of the date of the trial court's ruling, and as of this date, that stormwater installation has been built in that setback area. Again, Neighbors for Responsible Land Use, which is cited again as a zoning case, involved construction. There were several buildings there on the property. It's a park and ride, and there's a big parking lot. But that had already begun construction by the time that case was decided. The other case that was cited by the court, Paulson versus Worcester City Planning Commission, they never even sought a stay, and the public improvements in that case to build a neighborhood were already built. We sought a TRO, a preliminary injunction, and now we're on appeal now in a timely fashion. We're still timely to stop the 36-foot height restriction. Additionally, the issue of whether something can actually be removed, we do believe that the stormwater improvements can be removed from this property. And several of the cases we cite, City of Brecksville ordered removal of a detached garage, Roman versus Modest ordered removal of fences. Because those structures violated deed restrictions, this stormwater installation is just like that, and it can be removed or moved to another location so that it no longer violates the deed restriction.
Okay, here, I know you said this isn't about zoning, but at least from the decision of the magistrate, and this portion was adopted by the court, the sewer was not found to be a structure, and the setback, if I'm right, they read to apply to structures, so it kind of, well, I understand how it's about a deed restriction, you can't totally skip the zoning issues. Or are you saying you can't?
Well, no, I'm saying actually that you can skip the zoning issues. You can go right to the deed restriction. And I will tell you, I have a 2-page outline of just that issue here. I'm not gonna read the whole thing, because it is a little bit complicated, and the wording is ambiguous and fuzzy. But because of that, we should have hashed this out further down below. It shouldn't have been through a motion to dismiss. And let me just read the one covenant. No improvement or structure shall be placed. No improvement or structure. Improvements, stormwater, we've admitted, that's an improvement. No improvement or structure shall be placed or construction within 70 feet on either side of the west line of parcel 2. That's what we're talking about. They went right in there with that stormwater improvement. Then it says, with the exception of any improvement or structure which is now or hereafter allowed without variance, blah, blah, blah.
Allowed by the zoning code.
Well,
Is that what it says, or do my notes
you know,
go off sync, which happens? You're also under your 5 minutes.
If we-
You can answer that.
if we go into the zoning code, I will say that the setbacks in Fairlawn, the setback requirements in Fairlawn don't apply to the improvements. And we've outlined this in the brief, I think, fairly well. It's kind of a complicated issue, but we do believe those exceptions have swallowed the whole in this case.
You can reserve the rest then.
Yes, thank you.
May it please the court, counsel, I have with me my partner David Sporer today. Thank you for your consideration. We're here today to ask the Court of Appeals to affirm the trial court's dismissal of the lawsuit below on mootness grounds. By way of introduction, this is a project in excess of $100 million on Embassy Parkway. It is a specialty orthopedic hospital. It is not for emergent care, it is for scheduled care. On a project of this magnitude, it is remarkable that Crystal Clinic has not sought a single variance for this project. To be clear, the property is located in a zoning district that permits hospitals as a conditional use. The zoning allows the building height up to 50 feet. The zoning has no setback restrictions for stormwater improvements. Again, Crystal Clinic did not seek any variance on the zoning side, and they've already spent millions of dollars by way of, they're very near completing the foundation that sits upon 500 aggregate piers that have been driven into the earth to support the foundation, and we expect the erection of structural steel in the coming days and weeks.
Okay, so Crystal Clinic did not seek any variance, I guess, and I understand how you mean that, but I also have to, you know what they say about assuming, but at least infer that Mr. Delavanese didn't just out of the clear blue sky lift that 36-foot height restriction.
In May of 2018, he recorded an affidavit that actually did did release the restriction as to this specific parcel. That was in May of 2018. But before we even get to those issues, and I'm happy to address those with the court, Crystal Clinic begins with the third assignment of error because the mootness doctrine is a question of subject matter jurisdiction, and this court continues to retain that subject matter jurisdiction. The court may consider extrinsic evidence to the record in considering that. As the court knows, we filed a fifth supplemental affidavit in support of the motion to dismiss on mootness grounds here in the last several days. And we've tried to do our level best to keep both the trial court and the Court of Appeals informed as to the progress on site. Appellants don't dispute the legitimacy of the doctrine, the mootness doctrine, or of any of the pertinent considerations. This case involves the construction of a building. Appellants have failed to obtain a stay or an injunction to halt that construction after nearly, let's say, 10 hours of evidentiary hearings in the trial court below. both by way of a TRO hearing and a preliminary injunction hearing where the court was able to consider a full referral of all issues to the magistrate. Crystal Clinic then lawfully commenced construction of this building, and really the only argument that they make, the appellants, is that Neighbors for Responsible Land Use somehow doesn't apply to this case. They attempt to distinguish it factually, and they attempt to distinguish between a declaratory judgment action for injunctive relief compared to a zoning case or a 2506 administrative appeal. The truth of the matter is Neighbors for Responsible Land Use does not draw those distinctions. Moreover, there is a case out of the 8th District Court of Appeals, Heaney, which does involve a deed restriction case where the court applied the mootness doctrine. So Ohio courts have applied the mootness doctrine in the context of an action for declaratory judgment and injunctive relief based upon deed restrictions. So the purported distinctions that they attempt to draw are inaccurate and immaterial. Neighbors for Responsible Land Use does not distinguish between buildings, improvements, or structures, nor does it distinguish between deed restriction cases and zoning cases. Moreover, there is no appropriate remedy left for the court to decide at this point in terms of the remedy they seek. The plans and the approvals from the city of Fairlawn and Summit County were based upon very specific engineered drawings, designs, architecture renderings. There is a substantial record below that evidences why the building is being constructed and the way that it's being constructed. And again, the zoning code expressly allows for buildings at a height of 50 feet in that location. I would ask the court to take note of the Martin decision, Martin v. Mohawk, which is cited in our brief. I think this case is more analogous to that, where the court found that in weighing the equities, courts have refused to order destruction of costly structures as a matter of economic waste, especially where the owner relied upon the assurances of building officials that the structure complied with all relevant codes. That is the case here. We did not commence construction until we had every single permit and approval that was required for us to commence construction. They've been unable to halt that construction via the injunctive relief that they sought below, and for those reasons, Your Honor, the case should be dismissed as moot, and the trial court's opinion should be affirmed on that basis. As to the other issues, while not expressly forming the basis of the trial court's opinion below, with the exception of count 1, the dismissal for failure to join indispensable parties, appellants didn't file any objections to the magistrate's opinion below. And so for that reason, we believe that those objections are waived. Moreover, I would note in the court's opinion, specifically, Judge Corbell-Jones states, the plaintiffs have filed a memoranda contra those positions and assert that the magistrate's decision should be affirmed in its entirety. The appellants below did not file objections from the magistrate's opinion on the issue of whether or not, first with respect to the 70-foot setback, whether or not that was fell within the exception and therefore was an improvement and thus not prohibited by the zoning code. That was never, objections were never filed by the appellants, and therefore we believe that that finding has been not challenged, and therefore it's been waived. Also, with regard to the delegatee's deed restrictions, there were no objections filed to the finding that, one, they were not intended beneficiaries of those deed restrictions, and two, they did not appeal whether or not they had standing to assert some enforceable rights under those deed restrictions. Again, objections were not filed to the magistrate's decision below, and for that reason we believe that those objections have been waived and that the trial court properly could find on alternate grounds reasons to dismiss the case. As for the issue first on the setback, there's no question but that there are 4 similarly situated neighbors that have the exact same rights, and whether or not they make the arguments or made the arguments below, the point is those rights could be prejudiced by the outcome of the opinion by not being named in the litigation. Under 2721.12, the revised code, the declaratory judgment statute, those are substantive rights. Those are procedural and jurisdictional issues that Having not named the appropriate parties, the court was well within its right to dismiss count 1. I'll distinguish, by the way, count 1 from count 2. Count 1, they asserted a legally protected interest as successors in interest to the Crystal Lake Association deed restrictions. Comparatively speaking, the Deleganese deed restrictions, they sought relief in the form of equity. Nowhere are they named in the Deleganese deed restrictions. In fact, Deleganese expressly reserved unto himself the ability to modify and to amend those deed restrictions, which he properly did in May of 2018 when he recorded an affidavit of facts that said that the deed restrictions no longer apply to this property. With that, I think the balance of our arguments are set forth adequately in the briefing, and I would entertain any questions that the panel may have for me.
All right, there are no questions, thank you.
Thank you.
Thank you. I just wanted to deal right up front with the magistrate's opinion. What she found is that we did not have a likelihood of success on the merits. And, you know, we believe that that opinion deals with the standards for temporary restraining orders and preliminary injunction. And that case then was continuing on to the judge at that point to flesh this out over time. And the judge ultimately ruled without hearing from us or allowing us to take any further discovery or depositions or anything like that. So I think that the magistrate's opinion is limited to the TRO and preliminary injunction. I think that her findings were certainly still in contest in this case. I appreciate that the Crystal Clinic has spent millions of dollars. It doesn't mean that this couldn't be restructured to meet the height restriction. Crystal Clinic, when it comes in, argues that, okay, well, zoning, Fairlawn zoning allows this, hospitals allowed in this area based on a conditional use, but again, that is not the point. Crystal Clinic knew of these deed restrictions, and certainly could have looked and certainly ran its title on this land and could have seen what all these limitations were, yet did nothing to address the needs of the residents or approach the residents about the deed restrictions. Basically, this case is about broken promises by Mr. Deleganese. When he originally said, I'm sorry?
He's not a party by anyone, correct?
He is not a party.
And never has been.
No, he has not been a party. But the broken promises were inherited by Crystal Clinic. And they start way back when this was designed initially as a residential area. They go way back to when it was moved from Bath to Fairlawn. And throughout that process, Deleganese, who sold the property, Crystal Clinic, promised there would be a 36-foot height restriction, promised that there would be a buffer zone in the 70-foot area. Those promises were inherited by Crystal Clinic when they acquired this property, and they're contained throughout the documents. And it's those circumstances that give my clients the right to enforce this based on the deed restrictions. Thank you very much. If there are no more questions.
There appear to be no more questions. Thank you both for very good arguments. We'll take the matter under advisement. Issue our written opinion in due course. It'll be mailed both sides as well as posted on our website and that of the Supreme Court.